Welcome to the HR Empowerment Podcast, where we will uncover strategies and new insights from HR professionals who discuss up-to-date regulations, best practices, and the most pressing topics like diversity and equity, leadership, dealing with difficult situations, and much more that affect your bottom line and business. Thanks for joining us.
Hey, everybody. Wendy Sellers here, the HR lady. Thanks for coming today. First of all, I want to make an announcement about how we are changing our podcast from a 5-day series to once a week, 30-minute podcast. Therefore, you will receive 0.5 credits if you are listening to the podcast through the auroratrainingadvantage.com website. So make sure you are logged in when you listen. With that said, this is our first podcast of that series. And it's a little bit different because there has been major changes in the federal government surrounding affirmative action. And then also DEI. The federal government has clarified what diversity, equity, and inclusion is, what is legal, and even more importantly, what is illegal. There have also been new publications that have been released from the federal government, specifically the Equal Employment Opportunity Commission, which I am going to go through today and explain the main set of questions and answers in the one publication. And then I will also provide you with some resources at the end of this podcast so that you can go and gather more information. Their secondary publication is aimed at employees who feel that their rights may have been violated due to company DEI initiatives. We've got a lot to cover, and it's not exactly fun, but it is very, very important. As the EEOC take a stance on DEI after affirmative action programs have been banned and tossed out. Let's dive in. With the end of affirmative action in early 2025, employers have been hearing about illegal diversity, equity, and inclusion for weeks. But what does it actually mean? Until yesterday, no one knew for sure. The Equal Employment Opportunity Commission just clarified DEI programs cross the line into unlawful discrimination if they involve employment decisions based on race, sex, or other protected traits. That includes hiring, firing, promotions, pay, training, and more. Examples of illegal DEI practices are as follows: hiring, firing based on race or sex, promotions and demotions influenced by identity, pay differences tied to protected traits, exclusive mentorship or training programs, work assignments based on demographics, quotas or reserved positions. For example, a mentorship program open only to women and people of color could violate Title VII. So could hiring preferences that automatically exclude other qualified candidates. Setting quotas risks legal trouble in 2025, and DEI quotas were never legal, by the way, and never the intent of affirmative action programs. So how can you keep DEI compliant? First, base decisions on merit and excellence, not identity. Second, make programs inclusive and open to everyone. Do not make decisions based on personal characteristics, such as race or gender. That is discrimination and always was. And third, encourage collaboration without requiring participation based on identity. I firmly believe that an intentional focus on diversity, inclusion, accessibility, belonging, and equality matters, but intent doesn't override the law. Keep initiatives fair, inclusive, and legally sound. Okay, now I want to talk to you about suggested ways to diversify your workforce without engaging in unlawful discrimination. In 2024, Andrea Lucas, the current Equal Employment Opportunity Commission acting chair, did a podcast interview in which she suggested 11 ways to diversify your workforce without engaging in unlawful discrimination. I will read the 11 items for you. By the way, on March 17, 2025, there was a press release that Andrea Lucas sent letters to 20 law firms requesting information about DEI-related employment practices. Okay, here are those 11 ways to diversify your workforce without engaging in unlawful discrimination. Number 1, review job descriptions. Remove unnecessary career requirements. I have been saying this my entire career. Number 2, audit hiring materials. Evaluate job descriptions, interview questions, and preferences for bias. Number 3, standardize interviews. Use consistent interview questions for similar jobs and eliminate unnecessary, subjective questions. Turns out her and I are more on the same page than I thought, so far anyway. Number 4, reform internal hiring and promotion processes, remove unnecessary formalities, post internal jobs transparently, and consider an opt-out promotion method instead of requiring employees to self-nominate. Everyone should be considered for promotions, not just though waving their arms. However, people may not want a promotion, especially if it comes with more responsibilities and stress. Let them opt out. Number 5, standardize sponsorship programs. Replace exclusive mentorship or sponsorship networks with programs open to all employees without race or sex restrictions. Number 6, expand leadership development. Offer leadership training broadly to all employees at a certain level rather than restricting access. Number 7, support first-generation professionals. Provide training and mentorship for first-generation professionals or college graduates to promote social mobility. Well, I wish I would have gotten this, but I am grateful for the mentoring I did eventually receive. Okay, moving on to the next few suggestions. Number 8, conduct privilege audits. Identify and address workplace discrimination, harassment, and systemic barriers. Number 9, expand recruiting efforts. Use diverse recruitment methods, such as wide-format job postings, multilingual applications, and alternative literacy requirements. Number 10, apply job requirement changes equally. For example, if lowering GPA cutoffs or other requirements, ensure the changes apply to all applicants, not specific groups. And number 11, oh, I love this one. Fix workaholic culture in leadership. Address leadership cultures that disproportionately harm caregivers and those with additional family responsibilities. Ensuring work-life balance is valued. Remember that these are not my suggestions, although I do agree with them. They are directly from Andrea Lucas, the current Equal Employment Opportunity Commission acting chair. If you are not complying, you may be setting yourself up for legal trouble. The next part of this podcast goes much more in deep to the topic of DEI and the new guidance for both employers and employees that came out from the Equal Employment Opportunity Commission on March 19, 2025. So hang on tight. The Equal Employment Opportunity Commission is doubling down on the issue of diversity, equity, inclusion, preferences, and quotas. There are now 2 publications related to DEI in the workplace and how to address discrimination related to DEI if it is happening. The first publication is What You Should Know About DEI-Related Discrimination at Work, and the second new publication from the Equal Employment Opportunity Commission is What to Do If You Experience Discrimination Related to Diversity, Equity, and Inclusion at Work. The links to both of these can be found on my blog at thehrlady.com. If your company was engaging in preferences or quotas, you were violating the law. DEI and affirmative action were never about preferences or quotas. That was a complete misconception. If your company used race, gender, age, etc. as a motivating factor to select, promote, or terminate an employee, you were and still are violating the law. Here is the one publication that the Equal Employment Opportunity Commission released. It is called What You Should Know About DEI-Related Discrimination at Work. Diversity, equity, and inclusion is a broad terminology that is not defined in Title VII of the Civil Rights Act of 1964. Title VII prohibits employment discrimination based on protected characteristics such as race and sex. Under Title VII, DEI initiatives, policies, programs, or practices may be unlawful if they involve an employer or other covered entity taking an employment action motivated, in whole or in part, by an employee's or applicant's race, sex, or another protected characteristic. 1. In the new guidance questions, If I believe I've experienced discrimination related to DEI at work, can I file a lawsuit in federal court alleging a violation of Title VII without taking any other steps? The answer is no. Before you can sue your employer in federal court for a violation of Title VII, you first must file a charge of discrimination, an administrative complaint, with the U.S. Equal Employment Opportunity Commission. After you file a charge of discrimination with the Equal Employment Opportunity Commission, there are other steps in the administrative process that must be completed before you can file a lawsuit in federal court. To learn more about these steps, please visit the website listed on their page, which will be on my website blog, thehrlady.com. So, basically, unless you timely bring an EEOC charge first, you cannot get a right to sue letter, also known as a notice of right to sue, that would allow you to bring a Title VII claim in federal court. The second question is, if I believe I've experienced discrimination related to DEI at work, what federal government entity can help me? Well, if you are not a federal employee, you first need to file a charge of discrimination with the Equal Employment Opportunity Commission. This is true no matter what type of non-federal employer you work for, a private sector employer or a state or local government employer. An EEOC charge is an administrative complaint. So again, unless you timely file a charge of discrimination with the EEOC first, you cannot get a right to sue letter. The EEOC enforces Title VII against private sector employers with 15 or more employees, and the Department of Justice enforces the statute against state and local government employers. For businesses and other private sector employers, the EEOC both investigates charges of discrimination against these employers and is authorized to bring a lawsuit against them. The EEOC can file a lawsuit after the agency has determined there is reasonable cause to believe that discrimination has occurred, and the agency is unable to resolve the matter through a process called conciliation. For state and local government employers, the EEOC is responsible for investigating charges of discrimination against such employers. If the agency determines there is reasonable cause to believe that discrimination has occurred and the agency is unable to resolve the matter through conciliation, the EEOC then refers those charges to DOJ for potential litigation by the department. The third question that the EEOC defines is, what if I am a federal employee and have experienced discrimination related to DEI at work? What is the complaint process? They answer it is, if you are a federal employee and believe your federal agency employer discriminated against you based on a protected characteristic as a result of, or related to, DEI, you first must contact an EEO counselor at your federal agency employer. Check out the EEOC overview of the federal sector EEO complaint process for more details and steps. The fourth question that the EEOC defines is, do Title VII's protections only apply to individuals who are part of a minority group, such as racial or ethnic minorities, workers with non-American national origins, diverse employees, or historically underrepresented groups, women, or some other subset of individuals? The answer is no. Title VII's protections apply equally to all workers. Different treatment based on race, sex, or another protected characteristic can be unlawful discrimination, no matter which employees or applicants are harmed. This has been the long-standing position of the EEOC and the Supreme Court. The EEOC does not require a higher showing of proof for so-called reverse discrimination claims. The EEOC position is that there is no such thing as reverse discrimination. There is only discrimination. Yes, you heard that right. There is no such thing as reverse discrimination according to the EEOC. The EEOC applies the same standard of proof to all race discrimination claims, regardless of the victim's race. The fifth question that the EEOC addresses is, are only employees protected from DEI-related discrimination at work? The answer is no. Title VII protects employees, applicants and training or apprenticeship program participants. Title VII also may apply to interns. Depending on the facts, interns may be covered as employees, as applicants, or as training program participants. A charge of discrimination may be filed with the EEOC by any person claiming to be aggrieved. Additionally, a charge can be brought on behalf of an aggrieved person by a third party, such as an organization. Finally, a commissioner of the EEOC may bring a charge. The sixth question is, are only employers covered entities under Title VII? That is, entities which must comply with Title VII's prohibition on discrimination? The answer is no. Title VII applies to employers with 15 or more employees, employment agencies, including staffing agencies, entities which operate training programs, including on-the-job training programs, and labor organizations, like unions. Employers can be liable for the actions of their agents, including recruiters and staffing agencies. Okay, so the seventh question that the EEOC asks in the guidance is, when is a DEI initiative, policy, program, or practice unlawful under Title VII? The answer is, under Title VII, an employer initiative, policy, program, or practice may be unlawful if it involves an employer or other covered entity taking an employment action motivated, in whole or in part, by race, sex, or another protected characteristic. Among other things, Title VII bars discrimination, aka disparate treatment, against applicants or employees in hiring, firing, compensation, or any term, condition, or privilege of employment. The prohibition against discrimination applies to a wide variety of aspects of employment. In order to allege a colorable claim of discrimination, workers only need to show some injury or some harm affecting their terms, conditions, or privileges of employment. The prohibition against disparate treatment, including DEI, related disparate treatment, includes disparate treatment in hiring, firing, promotion, demotion, compensation, and fringe benefits. It also includes access to or exclusion from training, including training characterized as leadership development programs, as well as access to mentoring, sponsorship, or workplace networking or networks. Internships, including internships labeled as fellowships or summer associate programs. Selection for interviews, including placement or exclusion from a candidate slate or pool, or job duties or work assignments. Phew, that is a lot to consider. Title VII also prohibits employers from limiting, segregating, or classifying employees or applicants based on race, sex, or other protected characteristics in a way that affects their status or deprives them of employment opportunities. This prohibition applies to employee activities that are employer-sponsored, including by making available company time, facilities, or premises, and other forms of official or unofficial encouragement or participation, such as employee clubs or groups. In the context of DEI programs, unlawful segregation can include limiting membership in workplace groups, such as employee resource groups, business resource groups, or other employee affinity groups, to certain protected groups. Unlawful limiting, segregating, or classifying workers related to DEI can arise when employers separate workers into groups based on race, sex, or another protected characteristic when administering DEI or any training, workplace programming, or other privileges of employment, even if the separate groups receive the same programming content or amount of employer resources. The EEOC goes on to explain that employers instead should provide training and mentoring that provides workers of all backgrounds the opportunity, skill, experience, and information necessary to perform well and to ascend to upper-level jobs. Employers also should ensure that employees of all backgrounds have equal access to workplace networks. The next question, number 8, is, can an employer excuse its DEI-related considerations of race, sex, or another protected characteristic, provided that the protected characteristic wasn't the sole or deciding factor for the employer's decision or employment action? The answer, again, is no. For there to be unlawful discrimination, race or sex, or any other protected characteristic under Title VII, does not have to be the exclusive, sole reason for an employer's employment action, or the but-for deciding factor for the action. An employment action still is unlawful, even if race, sex, or another Title VII protected characteristic was just one factor among other factors contributing to the employer's decision or action. The ninth question is, can an employer justify taking an employment action based on race, sex, or another protected characteristic because the employer has a business necessity or interest in diversity, including preferences or requests by the employer's clients or customers? The answer is no. Employers violate Title VII if they take an employment action motivated in whole or in part by race, sex, or another protected characteristic. Title VII explicitly provides that a demonstration that an employment practice is required by business necessity may not be used as a defense against a claim of intentional discrimination. In particular, client or customer preference is not a defense to race or color discrimination. Basing employment decisions on the racial preferences of clients, customers, or coworkers constitutes intentional race discrimination. Employment decisions based on the discriminatory preferences of clients, customers, or coworkers are just as unlawful as decisions based on an employer's own discriminatory preferences. Title VII allows employers to raise a bona fide occupational qualification, also known as BFOQ, as an affirmative defense in very limited circumstances to excuse hiring or classifying any individual based on religion, sex, or national origin. The exemption applies where religion, sex, or national origin is a bona fide occupational qualification, reasonably necessary to the normal operation of that particular business or enterprise. However, this very limited carve-out for BFOQ excludes race and color. Title VII does not provide any diversity interest exception to these rules, nor has the Supreme Court ever adopted such an exception. No general business interests in diversity and equity, including perceived operational benefits or customer-client preference, have ever been found by the Supreme Court or the EEOC to be sufficient to allow race-motivated employment actions. The 10th question is, can an employer's DEI training create a hostile work environment? Their answer is that Title VII prohibits workplace harassment, which may occur when an employee is subjected to unwelcome remarks or conduct based on race, sex, or other protected characteristics. Harassment is illegal when it results in an adverse change to a term, condition, or privilege of employment, or it is so frequent or severe that a reasonable person would consider it intimidating, hostile, or abusive. Depending on the facts, an employee may be able to plausibly allege or prove that a diversity or other DEI-related training created a hostile work environment by pleading or showing that the training was discriminatory in content, application, or context. In cases alleging that diversity trainings created hostile work environments, courts have ruled in favor of plaintiffs who present evidence of how the training was discriminatory, for example, in the training's design, content, or execution, or at the motion to dismiss stage, who make plausible allegations that explain how the training was discriminatory. And the final question in the new publication is, does Title VII protect employees who oppose unlawful policies or practices, including certain DEI practices or trainings? They state that Title VII prohibits employers and other covered entities from retaliating because an individual has engaged in protected activity under the statute. Generally, protected activity consists of either participating in an EEO process or opposing conduct made unlawful by Title VII. Depending on the facts, protected opposition could include opposing unlawful employment discrimination related to an employer policy or practice labeled as DEI. As previously noted by the Commission, courts have held that opposition to a DEI training may constitute protected activity if the employee provides a fact-specific basis for his or her belief that the training violates Title VII. Well, folks, There you have it. I know that was a lot, but I also want you to know that the EEOC also released another publication titled, "What Should I Do If I Encounter Discrimination Related to DEI at Work?" Okay, so now we're diving into some crucial new guidance from EEOC. This second publication from the EEOC is primarily aimed at employees, but I strongly encourage everyone, employers, HR professionals, and business owners, to take note of this as well. Why? Because understanding these guidelines now can help you avoid legal trouble down the road. The document they published outlines key legal concepts, including disparate treatment, prohibited conduct related to limiting, segregating, or classifying employees based on race, sex, or other protected characteristics, harassment, and retaliation. It also highlights what employees should do if they believe they have experienced discrimination related to diversity, equity, and inclusion policies or initiatives. So let's break it all down so you can stay informed and protect yourself and your workplace from legal pitfalls. The section on understanding Title VII and discrimination is guidance on the Title VII of the Civil Rights Act of 1964. Title VII, as already discussed, is the federal law that prohibits employment discrimination based on race, sex, and other protected characteristics. What's important to note here is that Title VII applies equally to all employees. That means discrimination can occur against any racial, ethnic, or gender group, not just historically marginalized groups. One of the key points made in this EEOC document is that different treatment based on race, sex, or another protected characteristic can be unlawful discrimination, no matter which group is affected. So, if an employer makes a decision that favors or disadvantages an employee based on one of these characteristics, it could be considered discrimination under the law. And here's a crucial legal fact. Before any employee can file a lawsuit in federal court for workplace discrimination, they must first file a charge with the EEOC. The EEOC investigates these complaints and, if necessary, can file a lawsuit against private sector businesses. For state and local government employers, the Department of Justice may step in to file a lawsuit based on an EEOC charge. Next, the publication addresses, what does DEI-related discrimination look like? Now, let's get into the specifics of DEI-related discrimination. The term diversity, equity, and inclusion isn't defined under federal law, but under Title VII, any policy, program, or workplace action motivated, even in part, by an employee's race, sex, or another protected characteristic could be illegal. This means that while DEI programs are meant to foster inclusivity, they must be implemented carefully to ensure they don't lead to unlawful discrimination. Here are some examples of how DEI-related discrimination might occur. Disparate treatment. One of the most common ways DEI-related discrimination can occur is through disparity treatment. This happens when an employer makes employment decisions motivated, whether fully or partially, by race, sex, or another protected characteristic. Under Title VII, this could include decisions regarding hiring, firing, promotion, and demotion. It also includes compensation and fringe benefits, as well as any exclusion from training, mentoring, or sponsorship programs, plus selection for interviews or placement on candidate slates. For example, if an employer has a hiring or promotion quota to ensure a certain percentage of employees belong to a particular racial or gender group, that could be a violation of Title VII. The same applies if an employee is excluded from mentorship programs based on race or sex. The new publication also covers limiting, segregating, and classifying employees. Title VII also prohibits employers from limiting, segregating, or classifying employees based on race, sex, or another protected characteristic in a way that affects their status or employment opportunities. Some examples of potentially unlawful conduct include restricting membership in employee resource groups to only certain protected groups, separating employees into groups by race, sex, or another characteristic for training sessions, even if they receive identical content, assigning job roles based on protected characteristics. Moreover, the new EEOC publication informs employees about harassment in the workplace. Harassment is another major area covered under Title VII. Workplace harassment becomes illegal when it results in an adverse change to employment conditions, and it is so frequent or severe that it creates a hostile work environment. What does this mean for DEI-related workplace discussions and training? If an employee is subjected to unwelcome conduct based on race, sex, or other protected characteristics during DEI training or in the workplace, they could have a legitimate harassment claim. Employers must ensure that their DEI programs do not promote hostility or intimidation, even if they are intended to address past injustices. Retaliation protections. Okay, so this is a big one. Retaliation is illegal. If an employee objects to a DEI program, files a complaint, or participates in an EEOC investigation regarding potential discrimination, the employer cannot retaliate against them. Finally, the new publication from the EEOC covers relations. Retaliation includes firing, demotion, exclusion from career opportunities, unfair performance reviews, and hostile treatment from supervisors or peers. If an employee reasonably believes that a DEI training violates Title VII, their opposition to that training may be protected under the law. Who is protected by Title VII? The publication covers that too. It educates employees and all of us that Title VII applies broadly to employees, job applicants, interns, and participants in training programs. It informs readers that if they fall into any of these categories and believe they've been discriminated against under a DEI policy or initiative, they must act quickly because there are strict deadlines for filing a charge. It also goes into what they should do if they experience DEI-related discrimination. Whew, this is a lot of information to take in, and I get it. DEI, discrimination laws, and employer responsibilities are all evolving quickly. That's why staying informed is crucial. My final thoughts are that you should check out the links provided in this podcast description or on my blog for further reading. If you're an employer, I strongly recommend consulting with an employment attorney to ensure your DEI programs comply with Title VII. And if you're an employee, know your rights and don't hesitate to reach out for help if you believe you've been discriminated against. Thanks for tuning in today. Stay informed, stay empowered, and take care.
Welcome to the HR Empowerment Podcast, where we will uncover strategies and new insights from HR professionals who discuss up-to-date regulations, best practices, and the most pressing topics like diversity and equity, leadership, dealing with difficult situations, and much more that affect your bottom line and business. Thanks for joining us.